Good day, Doctor. We are from Group 1 Policy Marine. Today we will present about the legal institutions in Malaysia. First of all, Malaysia is a country that implements with democratic system based on the federal system. According to the federal constitutions, Malaysia powers hierarchies is defined into three branches, which is judiciary, legislature, and executive. This is to ensure the separation of power and avoid power from being dominated by certain branches. So first, judiciary. Judiciary is also known as the court system that is responsible to resolve the legal disputes by interpreting, defense, and apply the law in legal cases. There are several definitions for judiciary. Based on the Cambridge, judiciary is the government of a country which is responsible for the part of legal system, including all the judges in the court of the country. While for the equal obedience, judiciary is a government department that requires to make authoritative rulings on the applicability of the law under specific situations. There are several purposes for judiciary, such as have power to hear and determine civil and criminal matters, have the rights to interpret the country's constitutions, determine the validity of the law then made by the legislature or any act of the executive. This is to determine the legality, avoiding abuse of power, and protect people fundamental rights. Malaysia court system is divided into two, which is superior court and subordinate court. Federal court is the highest court, which can hear civil and criminal appeals from the Court of Appeals. Then the Court of Appeals can hear and determine civil appeals for cases exceeding 250,000 and any appeals that against the decisions of the court on criminal matters. Next, High Court. For civil and criminals, it can hear all the cases, but mainly limited to the cases not under the jurisdictions of the magistrate and section court. And for appellate, it can hear civil and criminal appeals from magistrate and section court with the amounts of any civil disputes must exceed 10,000. After that, Session Court can hear civil cases that the amount in disputes does not exceed 1 million and has all criminal cases except cases that the punishment with death. Magistrate Court is divided into two classes, which is first class and second class. For the first class, can hear the civil cases that do not exceed 100,000 and criminal that punishment of prison do not exceeding 10 years. While for second class, the civil cases do not exceed 10,000 and criminal not exceeding 1 year. Lastly, court for children, on previously known as juvenile court. It can hear and determine any cases against children under the age of 18, except cases with the death penalties, which should be heard in the High Court.
Based on Cambridge, bureaucracy is a system for controlling or managing a country, company, or organization that is operated by a large number of officials employed to follow rules carefully. While based on Encyclopedia Britannica, bureaucracy is a specific form of organization defined by complexity, division of labor, permanent, professional management, hierarchical coordination and control, strict chain of command, and legal authority. It is distinguished from informal and collegial organization. Bureaucratic organization can be found in both public and private institutions. In its ideal form, bureaucracy is impersonal and rational, and based on rules. I will share the purposes of bureaucracy in the public administration, since bureaucracy plays a very important role in the government. The first one is implementation of governmental policies and laws. The bureaucracy is responsible to carry out the government's policies. Next is the role in policy formulation. To formulate the policies, civil servants will supply the data needed by the political executive. Civil servants also formulate different choices of policies and describe every merits and demerits. Bureaucracy is also responsible to run the day-to-day of administration by following the policies, laws, regulations, and decisions of the government. The fourth one is advisory function. Advising the political executive is one of the important roles of bureaucracy. Usually, the experienced civil servant will provide expert and professional advice and information to the ministers. For the role in legislative work, civil servants will draft the bills which the ministers give to the legislature for lawmaking. Next is semi-judicial work. civil servant in charge in settling the discussion involving license, grants of permits, and many others. In collection of taxes and disbursement of financial benefits, one of the rules is giving advice to the political executive in regard to all financial planning, tax structure, and others. Next, keeping all the government records systematically is the sole responsibility of civil servants. Aside from collecting and analyzing all the data related to the government activities, they also collect and maintain essential socio-economic statistics that are used to formulate public policies and plans. Last but not least, in public relations, civil servants are the main agent who serve as two-way links. They talk about all the government's decisions to the people, and they also disclose about the needs, interests, and views of the people to the government. Two examples of civil servants are budget analysts and education funding analysts.
Next, legislature is a government branch responsible for enacting national laws and allocating funds needed to operate the government. Based on the Cambridge, the legislature is a group of people in a country or part of a country who have the right to make and change the law. While based on the Anglo-obedience, legislature is a legislative branch of government. It can legislations authorizing to create, amend, or repeal law. Besides that, it can create or impose new taxes, additional taxes, or cancel any taxes. It also can approve the annual national budget. It also can act as a representative of the people in the government and serve as a forum for citizens and a focus for public options on national affairs. In Malaysia, Parliament is the legislative authority. It has two levels, which is federal level and state level. At the federal level, the legislature belongs to the bicameral parliaments headed by the YTPA and comprises with the Dewan Negara and Dewan Rakyat, while the state level belongs to unicameral Dewan Undangan Negeri DUN, headed by the Sultan or YTPN. The function of the YTPA is to granting of access to the law and acted by the both houses of parliaments to summer periods and dissolve parliaments, or call upon the parliament's assemblies to hold a meeting, stop and dismiss it. The next one is Dewan Negara, or we known as House of Senate. Check the legislations passed by the Dewan Rakyat as represent the interests of the state. Well, for the Dewan Rakyat and House of Representatives to discuss the budgets and enact law during Senate join the meeting and have the rights to decide matters related to the fiscal policy. Yang di-Pertuan Negeri or Sultan, their function is almost allied with YTPA. They can dissolve DUN, call upon the state legislative assembly to hold a meeting, stop and dismiss it, or approval of state law passes by the state legislature. And lastly, for the DUN, Dewan Undangan Negeri, to enact state law under Malaysia constitutions to discuss and approve the national budget and as represents the interests of the state.
Next is executive. For the definition of executive, there are two forms, broad form and narrow form. So in the broad form, meaning all the functionaries, political power holder, and the permanent civil servant who undertakes the execution of laws and policies and run the administration of the state. So in the narrow form, only the executive heads who head the government department, formulate the policies and supervise the implementation of the laws and policies of the government. So in a broad and collective sense, so the executive organization embraces the aggregate or totality of all the functionaries and agencies which are concerned with the execution of the will of the state as that has been formulated and expressed in terms of law. There are several purposes of the executive. The first one is the enforcement of law. The primary function of the executive are to maintain and enforce law and order in the state. So wherever a breach of law is take place, so it is the responsibility of executive to plug the breach and bring the offenders to book. One is treaty making. It is the responsibility of the executive to decide which treaties are to be signed with other countries. So basically, each treaties must be signed by a member of the executive. The next one is defense, war and peace. One of the key purposes of the executive is to defend and preserve the unity and integrity of the country and protect it. So to organize a military for the defense of the state, to prepare for and fight for a war if necessary, or to negotiate and sign for a peace settlement after every war are the function performed by the executive. Okay, next is policy making. It is the executive responsibility which undertakes the task of policy making and development of planning. These are two most important functions of the executive because by this, the state can carry out their objective of promoting their welfare of its people. Last but not least, the executive can grant titles and honors. So for example is Prime Minister and Cabinet. Is civil society. Definition of civil society is referred to the space for collective action for same interest, purpose and value, generally distinct from the government and commercial profit actors. So the purpose. So the inclusion of the civil society voices which are essential to give expression to the marginalized and those who are not heard. Civil society organizations play multiple roles. They are an important source of information for both citizens and also government. They also monitor the government policies and action and also hold the government accountable. They also deliver service especially to the poor and to those who are underserved. For the example is the charities, the development of NGOs, the women organization, trade unions and also social movement.
So let's move on to the military and police. First and foremost, what are military and police? So the military is the all-legal structure that governs military personnel. According to the Ministry of Defence Malaysia 2010, the army is a military branch of service primarily focused on ground warfare, and police or law enforcement in Malaysia is performed by numerous law enforcement agencies and generally comes under the direct purview of the Royal Malaysia Police, the main government agency entrusted with the maintenance of law and order in the country. And the police is a constituent body of persons empowered by the state to enforce the law. You guys should know why government create the policy and law of two bodies of the agency. The purpose of military law has been created is because topic covered by the military cover service member conduct while in training or an active duty, protection of military purpose, and service member re-entry into civil society when their tour of duty are over. According to 2021 Malaysia Ministry Strength, primary objective of the National Defence Policy is to protect and defend national interests which form the foundation of Malaysia's sovereignty, territorial integrity, and economic prosperity. To achieve this objective, a requirement for a comprehensive strategy has been formulated as the underlying principle for national defenses. The overriding principle of this strategy is self-reliance, the prerequisite for which is total commitment for all sectors. According to my government policy's national defenses policy, the power of arrest and legitimate use of force, the term is most commonly associated with police. Service of a sovereign state that are authorized to exercise the police power of the state within the defined legal or territorial area of responsibility. Example of this legal institution, especially for military, are Malaysian Army, Royal Malaysian Navy, Royal Malaysia Air Force, and the police, Royal Malaysia Police, Private Security Services, Malaysian Maritime Enforcement Agency, Royal Malaysia Custom, Malaysian Anti-Corruption Commission, RELA, Immigration Department of Malaysia, Malaysian Road Transport Department. Okay, let's move on to the next legal institution.
Next, we're gonna move on to legal professions. According to law teacher, law profession is a vocation that is based on expertise in law and in its application. All the people with these vocations form a body of individuals who are qualified to practice law in particular jurisdictions. Mainly, there are two branches of the legal professions: solicitors and barristers. However, the legal profession in Malaysia is a fused profession between those two, unlike in England. The purpose of legal professions are to study, promote, uphold, and enforce the collection of rules imposed by the authority, ensure the rights of each person and the entire civil society, and to effectively implement the human rights function of the state by ensuring proper interaction in the activities of government bodies and civil society. In Malaysia, all advocates and solicitors have to abide to different types of law according to the region. For example, Legal Profession Act 1976 in West Malaysia, Advocates Ordinance of Sabah 1953 in Sabah, and Advocates Ordinance of Sarawak 1953 in Sarawak. Some examples for legal professions are jury, lawyer, attorney general, and judge. As an addition, I stumbled upon an interesting quote by Stephen Kiva, which says, "Law is one of the great professions. While medicine heals the body and clergy heals the soul, the law heals societal reefs." Thank you.